Hey there. My name is Ruben Rojas. I am an attorney in California, relatively new to the industry, and I'm revisiting some cases that I saw while I was in law school. If you're new to the channel, you should probably check out my first video, which is about torts, and my second video, which is about criminal law. This will kind of give you some context as to what the purpose of the channel is and where I'm going with it. If you haven't already seen it, here's a quick little recap. Law is very complicated. And it's complicated to an extent because we make it complicated. Not like lawyers, but the general system. See, the way that law is written, in part, is a lot like parables. It's kind of like reading the Bible, right? Like you read a story and then you get a lesson out of it, and then those stories kind of build on each other. What we're going to be covering today is constitutional law, which it's not what you might think in the sense of individual rights. That's a different course with different materials. This is more about the limits of government, what they're allowed to do, not so much focus on what people themselves are allowed to do and what they're not allowed to do. Okay, that said, my format is a little different. Rather than this being like a lecture style of teaching, it's more based, I think, on the Socratic method, or at least that's the intent. So we'll see how it goes. Now, if you're unfamiliar with the Socratic method, it was made famous by Socrates, which, as far as I know, is the founder, who was a very chaotic teacher because he never really gave you the answer. His method of teaching was more seducing the student into coming up with the answer themselves. I know that sounds really bad using the word seduction, but that's kind of the point, right? It's about asking the right questions and getting the thought process, getting those mental juices flowing, if you will, to get the student to come up with their own conclusion. Theoretically, the conclusion that the instructor wants them to come up with, but more importantly, for them to come up with their own thinking. That is, by the way, the method that law schools employ. The difficult part about it is that you have to have some sort of context in order for you to understand what it is that they're trying to teach you. And if you don't come from a long family of lawyers, you might not have that context. Okay, so we're going to be going over one of the first cases that you would see in law school, Marbury versus Madison. It is a Supreme Court decision. Like I said, my format's a little different. It's not like pre-scripted. I literally do not know what I'm going to say because I'm going to be reading these cases as if I'm reading them for the first time, even though now I'm an attorney. So it's not the first time that I've seen them, but it's the first time that I've seen them in, a couple years, right? Because you don't see like the same cases every day from law school. Okay. So I got this case from Justia, and they cover Supreme Court cases. To my understanding, they are not, this website is not like directly related to the Supreme Court. It's like their mission to cover Supreme Court cases. It's like, it's like news channels would say, right? Like it's not their job to make the news, it's just to report them. Same deal, right? Okay. So that being said, the reason why I'm doing it this way is because I'm more focused on teaching you how to understand law and how to read law than I am in teaching you what like the law is, if that makes any sense. Because once you understand the system and you understand the process, you can learn for yourself. You can once you know how to read a case and really understand it and you have that foundation, you can pretty much look at any case in its original text and understand it. Okay, right? Okay. Now, you will notice that this writing is pretty big. And part of the reason why is because I'm super blind and it's difficult for me to see. So, I like big text and I cannot lie. All right, here we go, people. It's time to lower up. Marbury versus Madison. Um, Whenever you're looking at these cases, as I mentioned in the previous videos, it's always important for you to know where this is occurring, like at what level of judicial review. In this case, it is a Supreme Court case, like U.S. Supreme Court, not just the Supreme Court of a state, right? Like, so it's a case that affects the entire nation, which is a pretty big deal. And if I remember correctly, like pretty much all the constitutional law cases that you see in law school are going to be Supreme Court cases. I don't, if there's an appellate one, you know, there might be a few, I don't remember, but the majority of them at least will be U.S. Supreme Court cases. And for the most part, most of the cases that you see in law school are going to be U.S. Supreme Court cases, or at least appellate cases. Okay, here we go. By the way, this is probably like one of the, if not the first, then one of the first cases you'll ever see. So I'm on this website. Over here, you see review and you see opinions. Anytime you're viewing a case for the first time, you want to see what the opinion is. Like the easiest way to understand a case through and through is to reverse engineer their logic. To an extent, because that might be actually how the judge came up with it. Like, this is going to sound really bad, but sometimes they come up with what they want to decide first, and then they come up with the reasoning afterwards, which is like not how it's supposed to be. But, you know, people are people and humans are humans, and people do things the way that they do things. So, like, yeah, I know. So yeah, start at the end and work your way backwards. Now, it just so happens at the end, let's see. So when we click on opinions, it takes us here. This is all like just background of. It's not the actual opinion itself. It's just like their little process, I think. Little process. The actual opinion itself. By the way, when you like here, this is how you know that the opinion has started. You see a judge's name, and in this case, because it's a Supreme Court case, you know, a Chief Justice, right? Or just a justice. It might not necessarily be the Chief Justice, not all the time. By the way, the U.S. Supreme Court is like a panel of judges. It's not just one, right? And so one of them writes the majority opinion. And I don't know what their process is for choosing like who is the one who writes the majority. Maybe it's just based on like, you know, they all choose like it's your turn, or, you know, I don't know. I don't know what process to go through, and I'm not gonna speculate on it. So right now, Justice Marshall, Chief Justice Marshall, is the one who delivered this opinion. Okay, all right. Okay, let's see what it says. At the last term, on the affidavits then read and filed with the clerk, a rule was granted in this case requiring the Secretary of State to show cause why a mandamus should not issue directing him to deliver to William Marbury his commission as a Justice of the Peace for the County of Washington in the District of Columbia. No cause has been shown, and the present motion is for a mandamus. The particular delicacy of this case, the novelty of some of its circumstances, and the real difficulty attending the points which occur in it require a complete exposition of the principles which the opinion to which has been given by the court is founded. Like I said, I'm reading these as if it's the first time. And it's been many years since the last time that I read these, so it will feel a lot like it's the first time, even for me. I have not reviewed these before, like getting the cameras rolling and stuff. So, and again, part of the reason for that is because I want you to see what I'm looking at and what I think about as I go through these cases. especially if you're a new law student or you're thinking about going to law school. This is the kind of things that you should be thinking about and the sort of manner that you should be thinking if you want to be successful in law school. So I should probably let's see. Yeah, I should probably go over some of the, if you don't already know, some of the core of like how a lawsuit works. Like, there's always going to be three perspectives to every story, right? There's going to be a plaintiff's perspective, a defendant's perspective, and the judge's perspective. And your job as a student is to try to see all those three perspectives and reconcile with it, right? And try to understand how the third perspective, the judge came up with a balance of the two a balance of the two differing plaintiff and defense positions. In the case of constitutional law, sometimes what you would see is an individual suing the government. You might see government suing each other, or you might see a government suing a person. It's not so clear cut sometimes. It's not like it's not so much like criminal law, where in criminal law it's always the government against a person, like at its core in the beginning, and as it appeals it changes, but in the beginning it's always the government suing a person for a criminal act. But in the case of constitutional law, it might just be a person saying, hey government, like, you're overstepping your bounds, right? And in this case, I believe that is exactly what it is, right? Like, it's been a while, so I don't remember exactly how it went. Let's see. These principles have been on the side of the applicant very ably argued at the bar. In rendering the opinion of the court, there will be some departure in form, though not in substance, from the points stated in the argument. In the order in which the court has viewed this subject, the following questions have been considered and decided. Okay, so this is really, really important, actually, because they're telling you these are the things that we looked at when it came to making this decision. Like, this is what this case is about. And they were really like clear cut about it. So by reading the opinion first, by reading the result first, and knowing that this is what they're looking at, when you go to read the facts, meaning the actual story, the backstory, and not just the ending, you can see what it is that they were looking at in those facts. So, has the applicant, okay, so it's like here, right? Has the applicant a right to the commission he demands? If I remember, now it's kind of starting to come back to me. If I remember, this case was about a judge who was losing his job over some alleged misconduct. And so he, if I remember, this has been a while, he was saying that his job, he had like a right to his job as a judge. And so whenever you go look at the facts, now you know in the back of your head, okay, I'm looking for what it is that the judge said, which in this case is the plaintiff, that, like, what is he saying gives him the right to the commission as a judge? Like, what gives him, like, what is he saying? What background facts is he using to support his position that he has a right, that it's not like a privilege, right? It's correct, not right, but okay. So that's the first thing. And then second, if he has a right, so assuming that he was correct here, step 2, if he has a right and that right has been violated, do the laws of his country afford him a remedy? Okay, now we haven't talked about remedies. Remedies are something, at least in law school, that you wouldn't see until like the second year. Me personally, like, I feel like they should cover a little more in the first year, but I can see why they didn't, because it is like dry and confusing as a subject, Let me just a quick summary, right? In terms of constitutional law, the remedy is almost always a court order saying, no, you can't do this, or hey, you have to do this, ordering to the defendant. And in this case, if I remember, the state is trying to strip him of his commission as a judge, and the remedy that he is requesting essentially is to block them from being able to strip him of his job, right? So that's what we're going to be looking at, more than likely. Okay. And then 3, if they do afford him a remedy, is it a mandamus issuing from this court? Okay. So they're gonna be covering what a mandamus is, so I'm not gonna like do background research on that. If you are reading this for the first time, by the way, and you're like coming across words that you don't know, you do need to look them up. And you'll see me do that sometimes. I won't do it too often for the sake of time, but if there's like a word that I'm like, people might not know this, or I don't remember what it is, I'll look it up too, right? Matter of fact, one of the first things that they teach you in law school is like, you got to be super humble as far as your what you think you know, because there's, especially in the technical industries, you might be representing a client that has a vocabulary that you are not familiar with. Like you might think you know what it is, and you don't know what it is. And if you don't find out, that's a problem. Like if you had to represent them and you don't know what it is, you might not represent them correctly. So yeah, you gotta really humble yourself in this industry, which is ironic because we're kind of like well known for inflated egos. So I don't know. All right, let's see. The first object of inquiry is, has the applicant a right to the commission he demands? Okay, so they got like right into it, right? Okay. His right originates in the Act of Congress passed in February 1801 concerning the District of Columbia. After dividing the district into 2 counties, the 11th section of this law enacts. Okay, so now they're going into like the actual like statutory law, right? Okay. That there shall be appointed in and for each of the said counties such number of discrete persons to be justices of the peace as the President of the United States shall, from time to time, think expedient and continue the office for 5 years. Okay. So at least just based on what I'm reading here, it says 5 years, right? And whoops, they're gonna get into this later, but they're trying to end it early, so less than 5 years, like clearly less than 5 years, right? Okay. Let's see. It appears from the affidavits that in compliance with this law, a commission for William Marbury, okay, so this is, by the way, how you like see cases. In this case, it's Marbury versus Madison. They're always done by last names typically, unless it's a company and then it's like the name of the company, and there might be some abbreviations for, if there is company, I think if I remember it's Co, right? And then versus Madison, we haven't gone over this, but there's something called sovereign immunity. So you can't actually sue the government directly, because the government has the power to say whether or not it can be sued. It's kind of like the way to think about that, and we'll get into it much later, but the way to think about that is, if you have power, unlimited power, let's say, why would you give it to somebody else to use it against you? Like a government allowing its people to sue it is essentially like giving them a sword and then saying, okay, you want to do battle? Like we should do battle. So why would anybody want to do that, right? Okay. And that was, by the way, a really big issue for a little while. Um, and so what, at least in the US, what we came up with was, okay, you can't sue the government directly, but you can sue the person who made a decision that may be erroneous, and you can seek remedy like that. So Madison is the person in the government who is like making this enforcement against Marbury, right? So Marbury is suing the person in the government who is acting in the capacity of the government. Yeah. Okay. And by the way, by blocking, by the government then saying, "Hey, Madison, like you can't do this," then they effectively change the posture and the actions of the government, right? So, yeah. Okay. Okay. It appears from the affidavits that in compliance with this law, a commission for William Marbury as Justice of Peace for the County of Washington was signed by John Adams, then President of the United States, after which the seal of the United States was affixed to it, but the commission has never reached the person for whom it was made out. Okay. In order to determine whether he was entitled to this commission, it becomes necessary to inquire whether he has been appointed to the office. For if he has been appointed, law continues him in office for 5 years. So that's what we're talking about, right? Like the statute says, hey, if he's appointed 5 years, that's what it says. So that's what it's got to be, right? Okay. And he is entitled to the possession to evidences of office, which being completed became his property. Okay. We haven't talked about property law, so I don't want to go too far down this rabbit hole. Basically, just to, like, for now, for the sake of like understanding this case, if you have a right to work, then it becomes your property right. This is kind of, I don't want to say it's an issue, but it's a wrinkle in something that especially employment lawyers have to really like pay attention to, as far as I know, because there's at will states and there's right to work states, and so at will states there's no property right to your job, meaning that you can just, they can fire you and not provide a reason, right? Right to work states work a little different, and right to work positions work a little different, because it's a property right. So before you can be removed of something that belongs to you, they have to have like a legal reason. And I don't want this to become too confused, because at will states, for example, they can't like an employer can't fire you for an unjust reason. This is part of the reason why employers don't give reasons why they like let people go, by the way, because it's legally safer for them to just stay quiet than to say anything, even if there is a legitimate reason to let somebody go. Yeah, it's, this, we're in 2025, right? Like that's just how the world works right now. So, but if you work in a right to work state, they can't do that so easily. They have to actually like provide a reason, right? And that reason has to be legitimate. And in an at will state, for example, they don't have to provide a reason, but if they do, it has to be a legitimate reason. Like it can't be for discriminatory reasons, for example, right? Like they can't just say, because this person's too old, or because we wanted somebody that was unmarried and, now this person's married, or I actually don't know how it works in terms of gender. Like, I assume that if you got the job, they know that like what your gender is. Or, and this is going to be an issue in the future. Um, I'm trying to remember exactly if your protection is on sex or gender. And so, like in right now, this was a really big issue not too long ago. But like we haven't really decided what gender is, right? Like where are the limits? And so if for example the courts determine that you can discriminate on gender but not on sex, like that changes things, right? But if they say you can determine on you can discriminate on gender but not sex, that's also different, right? Like, or did I just say the same thing twice? I think I might have just said the same thing twice. You can discriminate on sex but not gender, or gender but not sex, or on neither, right? Like what's the difference? And if like right now we're trying to figure out, if there is a difference between gender and sex, like officially, right? Like right now it seems like it's like determined on which state you live in. It hasn't become like a legally significant difference yet. Maybe in the future it will be, maybe it won't. I don't know. But I anticipate that it's going to be something that courts are really going to look at in the future. Okay. So is it a property right? Like that's really kind of the question that we're going to be looking at, right? The second section of the second article of the Constitution declares, the president shall nominate and by which and with the advice of and the consent of the Senate shall appoint ambassadors, other public ministers and consuls, and all other officers of the United States whose appointments are not otherwise provided for. Okay. This section declares that he shall commission all the officers of the United States. An act of Congress directs the Secretary of State to keep the seal of the United States, to make out and record and affix the seal, said seal, to all civil commissions to officers of the United States to be appointed by the President, and with the consent of the Senate and by the President alone, or by the President alone, provided that the said seal shall not be affixed to any commission before the said have been signed by the President of the United States. Remember, this writing is from like 1801? Yeah, so they do write a little different back then than how we do now, and so it might sound a little strange saying it out loud. So if you think to yourself, "Oh, I gotta hear that again," and you gotta rewind, like by all means do so. I have to rewind my mind sometimes too, right? Okay. These are the clauses of the United States and laws of the United States which affect this part of the case. They seem to contemplate three distinct operations. The nomination, this is a sole act of the president and is complementary and completely voluntary, excuse me. The appointment, this is also the act of the president and is also a voluntary act, though it can be only performed by and with the advice and consent of the Senate. And the commission, the commission, to grant a commission to a person appointed might perhaps be deemed a duty enjoined by the Constitution. He shall, says the instrument, commission all the officers of the United States. So, okay, so they are making a distinction here. He shall means there's no other choice in like legal speak, right? Shall. Anytime you see shall, it's like this is it. There's no room for interpretation, right? Okay. The acts of the appointment to office and the commissions of the person appointed can scarcely be considered as one and the same, since the power to perform them is given two separate and distinct sections of the Constitution. The distinction between the appointment and the commission shall be rendered more apparent by adverting to that provision in the second section of the second article. And let me rewind here, okay? The distinction between the appointment and the commission will be rendered more apparent by adverting to that provision in the second section of the second article of the Constitution, which authorizes Congress. Okay, yeah. To vest by law the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. So they're talking about like the limits of like where it is, right? Like what they're required to do and what they're allowed to do. Another reason to use the word shall, by the way, or another way that shall will be interpreted is in that the position that it affects, in this case, the presidential powers to appoint, the president does not have any reason to have to explain himself as to why he's making a commission. Not explain to him and not explain why he's making that specific recommendation and commission, but a commission at all. Like they don't have to fight for it. It's not like other words like may. If he said he may, then he might have to explain himself as to why he should be allowed to do it, right? Like it's a matter of discretion. But in this case, shall means, okay, you do it, and we're not going to question the matter that you will have the power to do it. We might question who you chose, but not that you have the power to choose someone. Okay. Let's... Okay. Thus, contemplating cases where the law may direct the president to commission an officer appointed by the courts or by the heads of departments. In such case, to issue a commission would be apparent a duty distinct from the appointment, the performance which perhaps could not legally be refused. Though that clause of the Constitution which requires the president to commission all officers of the United States may never have been applied to the officers appointed otherwise than by himself, yet it would be difficult to deny the legislative power to apply it to such cases. Okay, so yeah, we're talking about like his ability to commission, right? Yeah, okay. Of consequence, the constitutional distinction between the appointment to an office and the commission of an officer who has been appointed remains the same as if in practice the president had commissioned officers appointed by the authority other than his own. Okay, so they're talking about whether he's appointed by himself or whether he's making a recommendation on behalf of another body. At least that's what I'm understanding of this. Maybe I need to review it again. Yeah, they're just saying like he has legislative power. It does say that it's important, right? Of consequence, the constitutional distinction between appointment to office and the commission of an officer who has been appointed remains the same as if in practice the president had commissioned officers appointed by an authority other than his own. I don't even, okay. Maybe this will make more sense why they even brought this up when we're looking at the facts. But it does say it's of consequence, so we need to like remember this in the back of our heads. All right, and we'll take a look at this later. Okay. It follows too from the existence of this distinction that if appointment was to be evidenced by any public act other than the commission, the performance of such public act would create the officer. And if he was not removable at the will of the president, would either give him a right to his commission or enable him to perform the duties without it. Okay, interesting. So we're talking about whether a commission creates that property right or not, right? If an appointment was to be evidenced by any public other than the commission, the performance of such public act would create an officer. And if he was not removable at the will of the president, would either give him a right to his commission or enable him to perform the duties without it. Okay, let's see if they expand on this a little more, because it is a little like what? Okay. These observations are premised solely for the purpose of rendering more intelligible, which apply more directly to the particular case under consideration. This is an appointment made by the President by which the advice and consent of the Senate and is evidenced by no act but the commission itself. In such a case, therefore, the commission and the appointment seem inseparable, it being almost impossible to show an appointment otherwise than by providing the existence of a commission. Still, the commission is not necessarily the appointment, though conclusive evidence of it. So they're saying that you can be, if I'm reading this right, they're saying that you can be appointed without a commissioning. So, okay, maybe that's what they were talking about earlier. Yeah, I think that's what they were talking, and we'll see more about this later. That you can be appointed without having a commissioning, but if you have a commissioning, you don't need to prove that you got appointed. Yeah, that seems right to me. Could be wrong, but that seems right to me. It seems like that's what we're talking about. So this is like a matter of evidence. They're saying, okay, you don't have to prove that you were appointed because you were commissioned, right? If he was commissioned, then that's what they're saying, right? Okay. And let's not forget about those 3 questions that they had earlier, right? We're still looking at property right. The commission. Let's take a look. Has the applicant a right to the commission he demands? Okay. If he has a right, invalidated to the country to afford him a remedy. If they afford him a remedy as a mandamus issue. Okay, all right. Okay. Let us return. Okay, so this is where we're at. But at what stage does it amount to this conclusive evidence? The answer to this question seems an obvious one. The appointment, being at the sole act of the president, must be completely evidenced when it is shown that he has done everything to be performed by him. All right. Should the commission, instead of being evidence of an appointment, even be considered as constituting the appointment itself? Still, it would be made when the last act to be done by the president was performed, or at the furthest when the commissioning was complete. The last act to be done by the president is the signature of the commission. He has been acted on advice and consent of the Senate to his own nomination. The time for deliberation has then passed. He has decided. His judgment on the advice and consent of the Senate concurring with his nomination has been made, and the officer is appointed. This appointment is evidenced by the open, unequivocal act and been the last act required from the person making it. Necessarily excludes the idea of its being so far as it respects the appointment in an incoherent and incomplete transaction. If I remember, incoherent is like not understandable, but let's see. What does the fucking word mean? Incoherent. What is you? All right. Just being and not so fully formed or developed. Rudimentary. Okay. Yeah. Just begun and not so fully formed to develop. Rudimentary. So like literally not advanced. Okay. All right, cool. An incomplete transaction. Okay, cool. All right. Some point of time must be taken when the power of the executive over an officer not removable by his will must cease. That point of time must be when the constitutional power of the appointment has been exercised. And this power has been exercised when the last act required from the person possessing the power has been performed. This last act is the signature of the commission. This idea seems to have prevailed with the legislature when the act passed converting the department. the Department of Affairs into the Department of State. By that act, it is enacted that the Secretary of State shall keep the seal of the United States, and shall make out and record, and shall affix the said seal to all the civil commissions, to the officers of the United States, to be appointed by the President. Provided that the said seal shall not be affixed to any commission before the same shall have been signed by the President of the United States, nor to any other instrument or act without the special warrant of the President therefor. The signature is a warrant for affixing the Great Seal to the commission, and the Great Seal is only to be affixed to an instrument which is complete. It attests by an act supposed to be of public notoriety the verity, what is verity? Verity. The state or quality of being true or real, or something that is true, especially a fundamental and inevitable true value. It can also refer to truth, accuracy, or honesty. Okay, all right. Okay, the verity of the presidential signature. Okay, so is it genuine? Is it a genuine signature? That's basically what they're saying, right? Like, is this a genuine diamond or a genuine signature? All right. It is never to be affixed till the commission is signed, because the signature which gives force and effect to the commission is conclusive evidence that the appointment is made. The commission being signed, the subsequent duty of the Secretary of State is prescribed by law, and not to be guided by the will of the President. He is to affix the seal of the United States to the commission, and is to record it. This is not a proceeding which may be varied if the judgment of the executive shall suggest one more eligible, but is a precise course accurately marked out by law, and is to be strictly pursued. It is the duty of the Secretary of State to conform to the law, and in this he is an officer of the United States, bound to obey the laws. He acts in this respect, as has been very properly stated by, let me rewind here. He acts in this respect, as has been very properly stated at the bar, okay, under the authority of law, and not by the instructions of the President. It is a ministerial act which the law enjoins a particular officer for a particular purpose. Ministerial act, that is. Always pay attention to like wording of like how a judge says something, because you kind of get a sense for their personality in there. And whenever you're looking at these arguments, like if you know you're going to argue before a judge, you should know about their personality, like, because if you understand their personality, you pretty much like know how they're going to respond to things. That's a big deal. That's a big deal in a court case. So really pay attention to that. Yeah. Okay. Ministerial. Okay. Yeah. So ministerial act. They're like, they're saying that this is holy, if you will. It's like a holy process. He acts in this respect as if it been properly stated by the bar under the authority of law, and not by the instructions of the President. It is a ministerial act which enjoins on a particular officer for that particular purpose. Yeah, okay. Cool. All right. If it should be supposed that the solemnity of affixing the seal is necessary, not only to the validity of the commission, but even to the completion of an appointment, still, when the seal is affixed, the appointment is made. I'm like, this case is starting to come back to me. This case was like it was like one of the very first Supreme Court cases, 1801, right? So this was the time that they were trying to really show the U.S. that the court is not an omnipotent structure. Like there was this balancing of powers thing that had just occurred, with the formation of the United States. And by doing that, by creating the separation of powers, now if I remember, this case was really like the first one that they said, you know what, this isn't our it's not our place. It's not our place to intervene here. If I remember, this was that case. And so that's why it's like long and like super convoluted, and they went into all this like ministerial acts and stuff like that. Like this was the case where the Supreme Court said, you need to take us seriously because we take ourselves seriously. Not in the like we're a big deal, we take ourselves seriously, but like in the sense of power, real power. By the way, if you didn't know this, real power is in restraint. It's not in like it's not an absolute power in the like, I can do anything kind of deal. It's more in the I could do this if I wanted to, but I'm not going to because I don't want to. Like if you want to see what real power looks like, that's what it looks like. And so that's what the court is doing here. They're saying, yeah, we could like intervene. Like you're asking us to intervene. We could say what we want to say, but we take our reputation and credibility seriously. And by having this concept of separation of powers, we're going to have to first start by deciding whether or not it's even our place to say anything. So they said a whole lot just to say it's not our place to say anything. Welcome to the US, and welcome to the US legal system. All right. So just like a quick shortcut on this case, right? Okay. Let's see. It should be supposed that the solemnity of affixing the seal is necessary, but not the validity of the commission. Not only the validity of the commission, but even to the completion of an appointment. Still, when the seal is affixed, the appointment is made, and the commission is valid. Excuse me. No other solemnity is required by law, no other act to be performed on the part of the government. All that the executive can do is invest the person with his office is done. All that the executive can do to invest the person with his office is done. And unless the appointment has been made, the executive cannot make one without the cooperation of others. After searching anxiously for the principles on which a contrary opinion may be supported, none has been found which appear of sufficient force to maintain the opposite doctrine. So they're saying that like they're looking for another way to the opposing side, and they can't find anything. They're basically saying this is how we do law. We look at both sides, right? And this, like I said, this is the court like saying like we have credibility because we do the work. That's basically what they're doing. Okay. Such as the imagination of the court could suggest have been very deliberately examined, and after allowing them all the weight which it appears possible to give them, they do not shake the opinion which has been formed. In considering this question, it has been conjectured that the commission may have been assimilated to the deed of the validity of which it was delivered is essential. The ideal is founded in the supposition that the commission is not merely evidence of an appointment, but it is itself the actual appointment, a supposition by no means unquestionable. But for the purpose of examining this objection fairly, let it be conceded that the principal claimed for its support is established. The appointment being under the Constitution to be made by the president personally, the delivery of the deed of appointment, if necessary to its completion, must be by the president also. It is not necessary that the delivery should be made. Let's see. Special uniform worn by a servant or official. Is there more definitions? I don't think it's a provision for food or clothing for servants, so okay. Let's see. A special uniform worn by a servant or an official. That's probably what it is, but let's see. It is not necessary that the delivery should be made personally to the grantee of the office. Okay, yeah. So the uniform, the official seal doesn't have to be delivered. Okay. It is never to be made. The law would seem to contemplate that it should be made to the Secretary of State, since it directs the Secretary to affix a seal to the commission after it shall have been signed by the President. If then the act of delivery be necessary to give validity to the commission, it has been delivered when executed and given to the Secretary for the purpose of being sealed, recorded, and transmitted to the party. But in all cases of letters patent, patent in this case meaning genuine, by the way, it's not like we're not talking about an engineering license, right? Or we're not talking about a license to a monopoly or an engineering design. We're talking about it being genuine and true. Okay. In all cases of letters patent, certain solemnities are required by law, which solemnities are the evidences of the validity of the instrument. A formal delivery to the person is not among them. In cases of commissions, the signed manual of the President and the seal of the United States are those solemnities. This objection, therefore, does not touch the case. It has also occurred as possible and barely possible that the transmission of the commission and the acceptance thereof might be deemed necessary to complete the right of the plaintiff. The transmission of the commission is a practice directed by convenience, not by law. It cannot therefore be necessary to constitute the appointment which must precede it and which is the mere act of the President. If the executive required that every person appointed to an office should himself make means to procedure his commission, the appointment would not be less valid on that account. The appointment is the sole act of the President. The transmission of the commission is the sole act of the officer to whom that duty was assigned, and may be accelerated or retarded by the circumstances which can have no influence on the appointment. Okay. Let me remind people here that this is 1801, so the word retarded is, used differently back then than it is now. Or rather, yeah, no, it is used differently back then than what it is now. It didn't have the stigma back then that it does today. And in fact, in aerospace, to my knowledge, the word retarded is still used. When you spool up an engine, that body, the throttle, to move it backwards, to spool down an engine, to like power it down, or to even go beyond if it has thrust reversers, to allow the airplane to go backwards with the engines. That position is to retard the engines. So it is an official word. Like no, they're not just being mean here. It is an official word. It has a real meaning. Okay, let's move on. Retarded by the circumstances which have no influence on the appointment. A commission is transmitted to a person already appointed, not to a person to be appointed, or not as the letter enclosing the commission should it happen to get into the post of office and reach him in safety or in miscarry. It may have some tendency to Elucidate. To make something clear or explain. Okay, so like making something lucid. All right, cool. I guess that's where the maybe that's where it came. Okay. It may have some tendency to elucidate this point and to inquire whether the possession of the original commission be indispensably necessary to authorize a person appointed to any office to perform the duties of that office. If it was necessary, then a loss of commission would lose the office. If it was necessary, then the loss of commission would lose the office. Huh. What are they talking about here? It has some tendency to elucidate the point to inquire whether the possession of any original commission be indispensably necessary to authorize. Whether possession of the original commission be indispensably necessary to authorize a person appointed by any office. Okay. Yeah. Well, let's see if they talk about this a little more. Like I said, they're kind of gonna, in this case, they're gonna kind of go on and on and on and on and on, you know, because they want to prove a point. That's, and not all constitutional laws like this. This is just the one where they say, we have a point in making a point, which is to make a point about the things that we make a point about. Yeah. Okay. Okay. Not only negligence, but accident or fraud, fire or theft might deprive an individual of his office. In such a case, I presume it could not be doubted, but that a copy from the record of the office of the Secretary of State would be, to every intent and purpose, equal to the original. The act of Congress has been expressly made so. To give that copy validity, it would not be necessary to prove that the original has been transmitted and afterwards lost. The copy would be complete evidence that the original had existed and the appointment has been made, but not that the original has been transmitted, if indeed it should appear that the original has been mislaid in the office of state, that the circumstance would not affect the operation of the copy. When all the requisites have been performed, which authorize the recording officer to record any instrument whatever, and the order for that purpose has been given, the instrument is in law considered as recorded, although the manual labor of inserting it in a book kept for that purpose may not have been performed. Okay, so they're saying if it happened, it happened, even if it hasn't been recorded. Okay, interesting. In the case of commissionings, the law orders the Secretary of State to record them. When, therefore, they are signed and sealed, the order for being recorded is given, and when inserted in a book or not, they are in law recorded. A copy of this record is declared equal to the original, and the fees to be paid by a person requiring a copy are ascertained by law. Can a keeper of a public record erase, therefore, a commission which has been recorded? Or can he refuse a copy thereof to a person demanding it on the terms prescribed by law? As such, a copy would, equally with the original, authorize the justice of peace to proceed in the performance of his duty, because it would equally with the original attest to his appointment. In the transmission of a commission, be not considered as necessary to give validity to an appointment, it's still less is its acceptance. The appointment is the sole act of the president. The acceptance is the sole act of the officer, and which, in plain common sense, posterior to the appointment. As he may resign, so may he refuse to accept, but neither the one nor the other is capable of rendering the appointment non-entity. That this is the understanding of government is apparent from the whole tenor of its conduct. A commission bears date, and the salary of the officer commences from his appointment, not from the transmission or acceptance of his commission. When a person appointed to an office refuses to accept that office, the successor is nominated in the place of the person who has declined to accept, and not the place of the person who had been previously in office and created the original vacancy. It is therefore decidedly the opinion of the court that when a commission has been signed by the president, the appointment is made, and the commission is complete when the seal of the United States has been affixed to it by the Secretary of State. Where an officer is removable at the will of the executive, the circumstance which completes his appointment is of no concern, because the act is at any time revocable, and the commission may be arrested. Arrested meaning ending, we're not talking about like going to jail. Though I guess, unless you think of arrest in going to jail as in like an arrest of your freedom, but like if you think about like cardiac arrest, like it's done, like it's not working, like that, okay? The commission may be arrested if still in the office, but when the officer is not removable at the will of the executive, the appointment is not revocable and cannot be annulled. It has conferred legal rights which cannot be resumed. Okay, so now we're talking about, again, we're going back to that property thing, right? Like, does he have a legal right or not? And they're saying if it can be ended by the executive, then there's no legal right. But if it's not revocable, then there's a right. The discretion of the executive is to be exercised until the appointment has been made. But having once made the appointment, his power over the office is terminated in all cases where by the law the officer is not removed by him. The right to the office is then in the person appointed, and he has the absolute unconditional power of accepting or rejecting it. Mr. Marbury, then, since his commission was signed by the president and sealed by the Secretary of State, was appointed, and as the law creating the office gave the officer a right to hold for 5 years independent of the executive. Oh, okay, so now we're saying he has a property right. Okay. The appointment was not revocable, but vested in the officer legal rights which are protected by the laws of this country. Okay. To withhold the commission, therefore, is an act deemed by the court not warranted by law, but violative of a vested legal right. Boom. This is what we're talking about, a property right. Okay. So they went through all that just to say, yeah, he has a property right. Remember, though, this is the first case, really, that is like about separation of powers. So they really like went all out. Okay. This brings us to the second inquiry, which is if he has a right and that right has been violated, do the laws of this country afford him a remedy? Okay. The very essence of civil liberty certainly exists in the right of every individual to claim the protection of the laws whenever he receives an injury. Now we're talking about remedies, right? One of the first duties of the government is to afford that protection. In Great Britain, we inherited our laws from Big Daddy Britain, right? So we're like Britain Jr., right? We inherited their legal system, right? The king himself is sued in the respectable form of a petition, and he never fails to comply with the judgment of his court. So like one of the few things that kings had to do was hold court, which was he was judge and jury and executioner. But so this is kind of what we're talking about, like sovereign immunity, right? Like this respectful form of a petition. When we're talking about like you can sue the person but not the government, that's what we're talking about, right? Yeah. In the third volume of his commentaries, page 23, Blackstone states 2 cases in which a remedy is afforded by mere operation of law. In all other cases, he says, it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action, a law whenever that right is invaded. Afterwards, page 109 of the same volume, he says, I am next to consider which injuries are as cognizable by the courts of common law. And herein I shall for the present and only remark that all possible injuries whatsoever and did not fall within the executive cognizance of either what? Ecclesiastial. Ecclesiastial? Meaning godlike? Let's see. Ecclesiastial. Relating to the Christian church or clergy. Okay, cool. How do you pronounce this?
Ecclesiastical.
Ecclesiastical. Ecclesiastical. Cool. All right. Military or maritime tribunals are, for that very reason, within the cognizance of the common law courts of justice, for which it is a settled and invariable principle in that the laws of England, in that very right, then withheld, must have a remedy in every injury its proper redress. The government of the United States has been emphatically termed as a government of laws and not of men. Huh. It will certainly cease to deserve this high appellation if the laws furnish no remedy for the violation of a vested legal right. Okay. If this obloquy, what does this mean? What does it mean? A strong public criticism or verbal abuse. Man, don't you just love the way people used to talk? Like, what? Like, come on. You couldn't have said strong public criticism or verbal abuse. All right. Is to be cast the jurisprudence of our country, it must arise from the peculiar character of the case. It behooves us then to inquire whether there be in its composition any ingredient which shall exempt from legal investigation or exclude the injured party from legal redress. In pursuing this inquiry, the first question that presents itself is whether this can be arranged with that class of cases which can come under the description of danum absci injuria, a loss without an injury. Well, I guess I just defined it here. Danum absci injuria. Don't you just love Latin? A loss without an injury. I wonder where like we recorded what these words mean, these Latin words mean, because it's a dead language. Like nobody practices them. So how do we know? How do we know that we know what we know and what we don't know of what we know? Yeah. This description of cases never has been considered, and it is believed never to have been considered after comprehending offices of trust and honor or of profit. The office of Justice of Peace in the District of Columbia is such an office. It is therefore worthy of the attention and guardianship of the laws. It has received that attention and guardianship. It has been created by special act of Congress and has been secured so far as the laws can give security to the person appointed to fill it for 5 years. It is not then on account of the worthlessness of the thing pursued that the injured party be alleged to be without remedy. Is it in the nature of the transaction? Is the act delivering or withholding a commission to be considered as a mere political act belonging to the executive department alone, for the performance of which entire confidence is placed by our Constitution in the supreme executive, and for any misconduct representing which the injured individual has no remedy? That there may be such cases is not to be questioned, but that every act of duty to be performed in any of the great departments of government constitutes such a case is not to be admitted. What are they saying here? that there may be such cases not to be questioned. Yeah, okay, yeah. But that every act of duty to be performed in any of the great departments of government constitutes a case is not to be admitted. Like admitted as in like publicly admitted? What are they talking about? Admitted as in allowed? Like, it's just the quiet part said out loud, you know? Is the act of delivering or withholding a commission to be considered a mere political act? We'll see this in the facts later, but like, if I remember, Marbury, now that's coming back to me, Marbury said that like, hey, you're removing me for office and you're saying it's misconduct, but really this is just a political act for the performance of which the confidence is placed in the Constitution, Supreme Executive, respecting which has no remedy. But what's the part that's to be admitted? The misconduct, that there's no remedy? Like what? What? I want to know. Okay. By the act of concerning individuals passed in June 1794, the Secretary at War is ordered to place on the pension list all persons whose names are contained in a report previously made by him to Congress. And if he should refuse to do so, would the wounded veteran be without remedy? Oh, so we're talking about wartime duties now. Okay. It is to be contended that where the law, in precise term, directs the performance of an act which an individual is interested, the law is incapable of securing obedience to its mandate. Is it on account of the character of the person against whom the complaint is made? Is it to be contended that the heads of departments are not amenable to the laws of their country? Whatever the practice on particular occasion may be, the theory of this principle will certainly never be maintained. No act of the legislature confers so extraordinary a privilege, nor can it derive countenance from the doctrines of the common law. After stating that personal injury from the king to subject is presumed to be impossible, we're talking about, again, sovereign immunity, right? Like, the king never did wrong. It was impossible, like way on back. Like, you know, it's kind of like he's never late to the party. Everybody else is just early. The king is never wrong, and they could never do anything wrong because everything belonged to the king. That was the way that it was. Everything, including people, belonged to the king, so he couldn't ever do any wrong. And that's kind of like the basis of sovereign immunity. So after stating that personal injury from the king to a subject is presumed to be impossible, Blackstone, Volume 3, page 255 says, but the injuries to the rights of the property can be scarcely committed. So basically, like, the king holding court against himself was like him being merciful. Yeah, okay. But the injuries to the right of property can scarcely be committed by the crown without the intervention of its officers, whom, by the law, in matters of right, entertains no respect or delicacy, but furnishes various methods of detecting the errors and misconduct of those agents by whom the king has been deceived and induced to a temporary injustice. Don't you just love the way they used to think back then? Okay, but the first is the various methods of detecting the errors and misconduct of those agents by whom the king has been deceived and induced to do a temper. So, okay, so this kind of tells you about like the view of like government, right? Like, way on back, it wasn't that the king did something wrong, or rather, it was like they're saying like the king didn't do anything wrong, but maybe his subjects, not his subjects, but maybe his support system, the nobles, you know, that like were supporting him and doing their duties, maybe they deceived him. And so he's ruling against those people, not against himself, in support of the person who is petitioning the king. Induced to do a temporary injustice. Isn't it so wild that they worded it like this? I mean, I don't know. Maybe I'm the only one that thinks this way. Anyway, by the act passed in 1796 authorizing the sale of the lands above the mouth of the Kentucky River, the purchaser, on paying his purchase money, becomes completely entitled to the property purchased, and in producing to the Secretary of State the receipt of the treasurer upon a certificate required by the law, and the President of the United States is authorized to grant him a patent. This is interesting. By the way, while we're here, you're going to learn this much later in property law, but no one actually owns land in the US. Like, y'all know that, right? Like, okay, you bought a house, that's not yours. Not really. That's You have temporary permission. You have temporary permission by the US to like occupy that area and do something with it. If it was actually truly 100% yours, you would be allowed to do anything on that space, including making your own laws. It would also mean that you would be responsible for protecting that land. So if somebody was to walk into that land, the police would not have jurisdiction to come to your rescue. So you actually don't really want to own land in that respect. Not 100%, right? So it's a temporary permission, like, and that's why it can be seized if if you commit a crime, that kind of thing, right? So if it was actually truly 100% like your land, then things would look very different. So food for thought. It is further enacted that all patents shall be countersigned by the Secretary of State and recorded in his office. If the Secretary of State should choose to withhold this patent, or the patent being lost should refuse a copy of it, it can be imagined that the law furnishes to the injured person. What? Can it be imagined to that the law furnishes to the injured person a remedy? Okay. It is not believed that any person whatever would attempt to maintain. Every time I see whatever here, I keep thinking I've like misread it. And I'm like, did it say whatsoever? And I just misread it? No, they just wrote different back then. Yeah. It is not believed that any person whatever would attempt to maintain such a proposition. It follows then that the question whether the legality, sorry, I was going to make an adjustment here. Okay. It then follows that the person, whether the legality of an act, the head of an act of the head of the department be examinable by in a court of justice, or must not always depend on the nature of that act. If some acts are examinable and others are not, there must be some rule of law guiding the court in the exercise of its jurisdiction. In some instances, there may be difficulty in applying the rule to particular cases, but there cannot, it is believed, to be much difficulty in laying down the rule. By the Constitution of the United States, the president is invested with certain important political powers, in the exercise of which he is to use his own discretion and is accountable only to his country and his political character and his own conscience. To aid him in the performance of these duties, he is authorized to appoint certain officers who act by his authority and in conformity with his orders. Okay, so yeah, we're talking about the appointment powers here. In such cases, their acts are his acts. So they're saying that the officers of the executive power, so the executive branch, are like an extension. They're his arms, right? His left and right arms. His or hers if we have a future female president. In such cases, their acts are his acts, whatever the opinion may be entertained of the manner in which the executive discretion may be used, still there exists, sorry, I lost my place there. Still there exists and can exist no power to control that discretion. The subjects are political. They respect the nation, not the individual rights, and being entrusted to the executive, the decision of the executive is conclusive. The application of this remark can be perceived by advertising to the acts of Congress for establishing the Department of Foreign Affairs. This officer, as his duties were prescribed by that act, is to conform precisely to the will of the president. He is the mere organ by whom that will is communicated. The acts of such an officer as an officer can never be examined by the courts. Ooh, okay. This is what we're talking about, that separation of power and like the basically jurisdiction over the over things that are political acts, right? So that is gonna be important. Like they're gonna look at that later. But when the legislature proceeds to impose on that officer other duties, when he is directed peremptorily to perform certain acts, when the right of individuals are dependent on the performance of those acts, he is so far the officer of the law is amenable. Let's see, what is this? I think that's like a close to agreeable, but I don't remember. Of a person open and responsive to suggest. So yeah, kind of like agreeable, amenable, easily persuaded or controlled. Yeah, boom. Okay. To the laws for his conduct, and cannot at his discretion sport away the vested rights of others. The conclusion from this reasoning is that where the heads of departments are the political or confidential agents of the executive, merely to the executive will of the president, or rather to act in cases in which the executive possesses a constitutional or legal discretion, nothing can be more perfectly clear than that their acts are only politically examinable. But where a specific duty is assigned by law, the individual rights depend upon the performance of that duty. It seems, but where a specific duty is assigned by law, and individual rights depend upon the performance of that duty, it seems equally clear that the individual who considers himself injured has a right to resort to the laws of his country for a remedy. Okay. This is that second part where they're like, okay, he has a right. We already established that. If he has a right, then is there a remedy, right? So they're saying there necessarily has to be a remedy if he has a right. Again, this is the first case, as far as I know, where they like really dive into this. So they're going all out, right? This is like all the background into like why there should be a remedy. Future cases, by the way, won't be this long. This is like an exceptionally long case for something that today we're like, yeah, duh. But back then it wasn't a duh moment, right? Like they were like, we're not so sure how this is gonna go. Let's see. Okay, like it wasn't so clear cut. Today we're like, yeah, there's no reason for us to go all in on all this stuff. If this be the rule, let us inquire how it applies to the case under the consideration of this court. The power of nominating to the Senate and the power of appointing the person nominated are political powers to be exercised by the president according to his own discretion. When he has made an appointment, he has exercised his whole power, and his discretion has been completely applied to the case. If by law the officer be removable at the will of the president, then a new appointment may be immediately made and the rights of the officer are terminated. But as a fact which has existed cannot be made, never to have existed, the appointment cannot be annihilated, and consequently, if the officer is by law not removable at the will of the president, the rights he has acquired are protected by law. This is where we're looking into that 5-year language that they looked at, which is a big deal, right? So I'm just making a prediction here because again, I don't remember how this case ends, but they're basically determining, can the executive branch remove can they remove this person before that 5-year time is up, right? Like that's basically what we're looking at. Or does it actually have to be 5 years? So anyway, and are not resumable by the president. Yeah. Okay. They cannot be extinguished by the executive authority, and he has the privilege of asserting them, like in a manner as if they had been derived from any other source. The question whether a right has been vested or not is in its nature judicial and must be tried by the jury, by the judicial authority. If, for example, Marbury has taken the oath of a magistrate and proceeded to act as one, in consequence of which a suit has been instituted against him, in which his defense has had depended on his being a magistrate, the validity of his appointment must have been determined by judicial authority. So, if he concedes that by virtue of his appointment he has a legal right either to the commission which has been made out for him or to a copy of that commission, and is equally a question examinable in a court, and the decision of the court upon it must depend on the opinion entertained of his appointment. What are they talking about? If he concedes that by virtue of the appointment he has a legal right to either the commission that was made out to him or to a copy of the commission, it is equally a question examinable in court. Okay, if he concedes this and this and this, and the decision of the court, it must depend on the opinion entertained of his appointment. Okay. Like I said, they're really like squeezing this for every moment that it's got. The question has been discussed, and the opinion is that the latest point of time which can be taken is that which the appointment was complete and evidenced was when the signature of the president and the seal of the United States was affixed to the commission. Okay, this is where we get into like some of the good stuff. It is then the opinion of the court, 1, that by signing the commissioning of Mr. Marbury, the President of the United States appointed him a Justice of Peace for the County of Washington in the District of Columbia. So he has an appointment. They've already talked us to death. Let's be honest. Okay. Yes. Okay. And that the seal of the United States affixed thereto by the Secretary of State is conclusive testimony as to the verity of the signature. So it's a genuine commissioning. It's not like a ceremonial commissioning. I don't know what other kind of commissioning that would be, but okay. And the completion of the appointment, and that the appointment conferred on him a legal right to the office for the space of 5 years. Okay, so boom, 5 years. Okay. Oh no. Okay. 2, that having this legal title to the office, he has a consequent right to the commission. We already talked about that. A refusal to deliver which is a plain violation of that right and for which the laws of his country afford him a remedy. So they're saying there must be a remedy, period. Okay. It remains to the inquired whether, so they're saying we haven't figured this out yet. It remains to be inquired whether he is entitled to the remedy which he applies. Okay. So they're saying there is a remedy, but is he asking for it? Because if he's asking for something else, he's not going to get it. And if he's not asking for what he should be asking for, he's not going to get it. So you can, in court, you can only get what you ask for, not what you are entitled to. So, and this applies, by the way, as far as I know, pretty much to like all cases. So let's say you get hit by a car, and your injury, the amount that it would, your financial injury, the amount that it would take for you to return you as if you had not been hit by a car was $1 million, let's just say. And you sue another person and you only ask for $1,000. you're gonna like that's you're not gonna get 1,000,000. You're gonna get 1,000. You can only get up to what you ask for, and that's part of the reason why it's part of the reason why lawyers ask for some like absurd things sometimes. They almost use it as a negotiation tactic. So yeah, juries can like make their own. They can make their own determination too, but you can only get the types of remedies that you ask for. So if you ask for a different thing, then yeah, things are a little different. Okay. He is entitled to the remedy which he applies. This depends on the nature of the writ he applied for. In this case, it was a mandamus. So we'll look at that later. The power of this court. So they're saying like the court itself has certain remedies it can give. So if you ask for a remedy that maybe you're entitled to, but the court doesn't have the power to give, then you can't get it there. You have to go to a different court. And hopefully you asked in a correct time frame. Okay. And that's because, there was separately courts of law and separately courts of equity. We mix those together now, so it's not so much an issue, but back then it was. So I keep doing this. The nature of the writ. Blackstone, in the third volume of his commentaries, page 110, defines a mandamus to be, oh great, they talked about it here, a command issuing in the king's name from the king's court, from the court of the king's bench, and directed to any person, corporation, or inferior court of the judicature within the king's dominions, requiring them to do the same particular thing, therein specified, which appertains to their office and duty, and which the court of king's bench has previously determined, or at least supposes to be the consonant to right and justice. Yeah. So we're going to call that estoppel now, but you'll see later. Okay. Lord Mansfield in 3 Boroughs 1266, in the case of the King versus Baker et al. Et al, by the way, means and others. So this is just Baker and other people. States with much precision and explicitness the cases in which this writ may be used. Whenever, says the very able judge, whenever, says that very able judge, why do they write it this way? Says that very able judge. Okay. There is a right to execute an office, perform a service, or exercise a franchise. More specifically, if it be in the matter of public concern or attended with profit, and a person is kept out of possession or dispossession of said right and has no other specific legal remedy, this court ought to exist by mandamus, upon reason of justice, as the writ expresses, and upon reason of public policy to preserve peace, order, and good government. In that case, he says, this writ ought to be used upon all occasions where the law has established no specific remedy, and where, in justice and in good government, there ought to be one. Okay, so they're saying you should use a mandamus if there's no other established remedy. Okay. In addition to the authorities now particularly cited, many others were relied on at the bar which show how far the practice has conformed to the general doctrines that have been just quoted. This writ, if awarded, should be directed to an officer of government, and its mandate to him would be to use the words of Blackstone, to do a particular thing therein specified, which appertains to his office and duty, in which the court has previously determined, or at least supposes to be constant to justice and justice. To be, no, or at least supposes to be constant to right and justice. I will learn how to read one day. I think that's going to be a goal in my lifetime. Learn how to read. And learn how to read good. Maybe one day I'll learn how to read and write good. Or in the words of Lord Mansfield, the applicant, in this case, uh, has a right to execute an office of public concern and kept out of possession of that right. These circumstances certainly concur in this case. Still, to render the mandamus a proper remedy, the officer to whom it is to be directed must be to whom, on the legal principles, such writ may be directed, and the person applying for it must be without any proper, specific, or legal remedy. With respect to the officer whom it would be directed, the intimate political relations subsisting between the President of the United States and the heads of departments necessarily renders any legal investigation of the acts of one of those high officers peculiarly irksome, bothersome, as well as delicate, and excites some hesitation with respect to the propriety of entering into such an investigation. Like, is this a proper thing to do? Okay. Impressions are often received without much reflection or examination, and is not wonderful. It is not wonderful that in such a case as this, the assertion by an individual in his legal claims in a court of justice, which claims it is the duty of the court to attend, should, at first view, be considered by some as an attempt to intrude into the cabinet and to intermeddle with the prerogatives of the executive. Now they're really talking about separation of powers, right? So like, they're like, don't touch my executive powers. Those are mine, right? Like, or these are theirs, right? It is scarcely necessary for a court to disclaim all pretensions to such jurisdiction. An extravagance so absurd and excessive could not have been entertained for a moment. The province of the court is solely to decide on the rights of individuals, not to inquire how the executive or executive officers perform duties in which they have a discretion. Questions in their nature political, or which are, by the Constitution and law, submitted to the executive, can never be made in this court. But if this is not such a question, if so far from being an intrusion into the secrets of the cabinet, it respects a paper which, according to the law, is upon record, and to a copy of which the law gives a right, on the payment of 10 cents, okay, it is, if it is no intermeddling with a subject over which the executive can be considered as having exercised any control, what is there in the exalted station of the officer which shall bar a citizen from asserting in a court of justice his legal rights, or shall forbid a court to listening to the claim or to the issue a mandamus redirecting the performance of a duty not depending on executive discretion but on particular acts of Congress and the general principles of law? If one of the heads of departments commits any illicit act under color of his office, by which an individual sustains an injury, it cannot be pretended that his office alone exempts him from being sued from the ordinary mode of proceeding, and is being compelled to obey the judgment of the law. How then can his office exempt him from a particular mode of deciding on the legality of his conduct, if the case be such a case as would, where any other individual in the party complained of, authorize the process? It is not the office of the person with whom the writ is directed, but by the nature of the thing to be done, that the propriety or impropriety of issuing a mandamus is to be determined. Okay, so now they're saying, like, do we have the power to, like, do this? That's what they're really looking at here, right? Where the head of a department acts in the case in which the executive discretion is to be exercised, in which he is a mere organ of the executive will, it is again repeated that any application to a court of control in any respect his conduct would be rejected without hesitation. But where he is directed by law to do a certain act affecting the absolute rights of individuals, in the performance of which he is not placed under the particular discretion of the president, and the performance of which the president cannot lawfully forbid, and therefore it is never presumed to have been forbidden. As, for example, to record a commissioning or a patent for land. It's so interesting they call it a patent in this case. Like, again, the language is a little different, right? Like, because we wouldn't call it a patent now. Like, now a patent is something totally different. Like now when we're talking about patents, we're talking about engineering. So yeah, anyway. Engineering or design, by the way, usually a physical things, but it could be software too. So yeah, we're probably not going to talk about that for quite a while, but yeah. Which has received all the legal solemnities, or to give a copy of such a record in such cases, it is not perceived on what ground the courts of the country are further excused from the duty of giving judgment as to the right to be done to an injured individual, that if the same services were to be performed by a person, not the head of a department. Okay. Maybe I don't know if I'm reading this incorrectly, but if I am, it seems like they're saying that the remedies from a person acting on behalf of government should be the same as a person who is not involved with government. In such cases, it is not perceived on what ground the courts of the country are further excused from the duty of giving judgment, that right to be done to an injured person, to an injured individual, than if the same services were to be performed by a person, not the head of a department. Maybe they talk about this more later. Let us see. Let us proceed. This opinion seems not now for the first time to be taken up in this country. It must be well recollected that in 1792 an act passed redirecting the Secretary at War to place on the pension list such disabled officers and soldiers as such be reported to him by the circuit courts, which act, so far as the duty was imposed on the courts, was deemed unconstitutional. But some of the judges, thinking that the law might be executed by them in the character of the commissioners, proceeded to act and report in that character. This law, being deemed unconstitutional at the circuits, was repealed, and a different system was established. But the question whether those persons had been reported by the judges as commissioners were entitled, in consequence of that report, be placed on the pension list, and was a legal question properly determinable by the courts, although the act of placing such persons on that list was to be performed by the head of the department. Okay. This law was deemed unconstitutional at the circuits. So the law, this was deemed to be unconstitutional. It must be well directing the Secretary of War to place on the pension list such disabled officers and soldiers will be reported by him by the circuit courts. Okay. So there was a law. Okay. This is, I'm guessing. Okay. Just guessing here. I'm guessing what they're talking about is not the actual act of, let me rephrase this, not the actual action of the Secretary at War to put officers and soldiers on that list, but the law itself So there was a law saying, hey, if the courts, so far as a duty was imposed on the courts, should be reported to him by the circuit courts. Yeah. So the act, which I mean it would be passed by Congress, said that the circuit courts had power over the executive, basically, the secretary at war. So it was Congress telling the executive branch, you have to do what the district court says. So it's a mixing of power, right? It's a mixing of these like three branches of power: the executive, the judiciary, and the legislative. So that was ruled to be unconstitutional, right? But some of the judges, thinking that the law might be executed by them in the character of commissioners, proceeded to act and report in that character. Okay, yeah. Okay, this law being deemed unconstitutional at the circuits was repealed. Okay, so that law that said the district courts would tell you which people to put was voided, if you will. But the question whether these persons which had been reported by the judges as commissioners were entitled, in consequence of that report, to be placed on the persons list was a legal question, properly determinable in the courts, although the act of placing such persons on the list was to be performed by the head of the department. So, yeah, okay. That this question might be properly settled, Congress passed an act in February 1793 making it the duty of the Secretary of War, in conjunction with the Attorney General, to take such measures as might be necessary to obtain an adjudication of the Supreme Court of the United States on the validity of such rights claimed under the act aforesaid. After the passage of this act, a mandamus was moved for, to be directed to the Secretary of War, commanding him to place on the persons list a person stating himself to be on the report of the judges. Okay. This is therefore much the reason to be believed that this mode of trying the legal right of the complaint was deemed by the head of a department and by the highest law officer of the United States the most proper which could be selected for that purpose. When the subject was brought before the court, the decision was not that a mandamus would not lie to the head of a department, directing him to perform the act enjoined by law, in the performance of which an individual had a vested interest, but a mandamus ought not to issue in that case. So they're talking about like should we intervene, right? The decision necessarily to be if the report of the commissioners did not confer on the applicant a legal right. The decision necessarily to be made if the report of the commissioners did not confer. Okay. The judgment in that case is understood to have directed the merits of all the claims in that description, and the persons on the report of the commissioners found it necessary to pursue the mode prescribed by the law subsequent to which had been deemed unconstitutional in that order to place themselves on the pension list. The judgment in that case is understood to have decided the merits of all claims of the description, and the persons on the report of the commissioners found it necessary to pursue the mode prescribed by law subsequent to that which had been deemed unconstitutional in order to place themselves on the pension list. Who placed themselves on the pension list? What are they talking about here? I'll have to look at that case later to see why do they keep referencing this? But okay. So they're saying there was a conflict of interest here. What are they talking about? I don't remember this. Okay, but the mode prescribed by law to which had been deemed unconstitutional in order to place themselves. Okay, maybe they talk about it more later. Let's see. The doctrine, therefore, now advances is by no means a novel one. Okay, so they're saying, hey, there's precedent here. Like we're not pulling this out of a hat. Okay. It is true that the mandamus now moved for is not for the performance of an act expressly enjoined by statute. Okay, cool. It is to deliver a commission on which subjects of the acts of Congress are silent. The difference is not considered as affecting the case, as it has already stated that the applicant has to that commission a vested legal right of which the executive cannot deprive him. He has been appointed to an office from which he is not removable at the will of the executive, and being so appointed, he has a right to the commission which the secretary has received from the president for his use. The act of Congress does not indeed order the secretary of the state to send it to him, but it is placed in his hands for which the person entitled to it, and cannot be more lawfully withheld by him than by another person. It was first doubted whether the action of detinue. I could probably just do this, huh? Yeah, okay. I'm old, I guess. I don't know. A legal claim to recover wrongfully detained goods or possessions. A legal claim to recover wrongfully detained goods or possessions. Huh, interesting. Funny because I don't think we use that anymore. Like, yeah, I don't think we use it anymore. But okay, cool. Like that word, maybe it's just one that's still technically correct, and you would probably look like a badass in court if you used it. But, yeah, okay. It was first doubted whether the action of detinue was not a specific legal remedy for the commission which has been withheld from Mr. Marbury, in which the case a mandamus would be improper. But this doubt has yielded to the consideration that the judgment in detinue is for the thing itself or its value. The value of a public office not to be sold is incapable of being ascertained, and the applicant has the right to the office itself or to nothing. Yeah, okay. So, they're saying we can either the value of the office cannot be sold. And yeah, okay. So they're saying that remedies can't be mixed. Remember I was talking about earlier, like you can only get what you ask for? He needed to ask for something different than what he's asking for. He's asking for a mandamus, when really he should have been asking for estoppel, basically, which is it's to prevent this action from occurring, right? Like, okay. Let's see. He will obtain the office by obtaining a commission or a copy of it from the record. This then is a plain case of a mandamus, either to deliver the commission or to copy of it from the record, and it only remains to be inquired whether it can issue from this court. Okay. So this is that third issue where they're like, okay, if he has a remedy, are we allowed to give that remedy? Is this like a thing we do here? Okay. This then is a plain case of a mandamus, either to deliver the commission or a copy of it from the record, and it only remains to be inquired whether it can issue from this court. Man, why does it keep doing that? Whether it can issue from this court. I'm like, if I get anywhere in the vicinity of this thing, it like shoots up. Okay. The act to establish the judicial courts of the United States authorizes the Supreme Court to issue writs of mandamus, in which cases warranted by the principles and usages of law, to any courts appointed or persons holding office under the authority of the United States. The Secretary of State, being a person holding an office under the authority of the United States, is precisely within the letter of the description, and if this court is not authorized to issue a written mandamus to such an officer, it must be because the law is unconstitutional, and therefore absolutely incapable of conferring the authority and assigning the duties which its words purport to confer and assign. The Constitution vests whole judicial power of the United States in one Supreme Court, and such inferior courts as Congress shall, from time to time, ordain and establish. This power is expressly extended to all cases arising under the laws of the United States, and consequently, in some form, may be exercised over the present case, because the right claimed is given by a law of the United States, and the distribution of this power. It is declared that the Supreme Court shall have original jurisdiction in all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party. In all other cases, the Supreme Court should have appellate jurisdiction. Okay, this is actually super important. This is like you will see this sort of thing. You're gonna see this right here. From law school exams to the bar. Like, this is where this came from, right? Yeah. So pay attention to this. This part is, this is where remember I was saying that this is like the real first case that the Supreme Court was saying like this is where our power is and where it ends. Like this is this case, and this is where they're talking about it, right? Yeah. It has been insisted at the bar that the original grant of jurisdiction to the supreme and inferior courts is general. In the clause, let me backtrack. I'm sorry. Original jurisdiction, meaning that they can see an issue from the beginning, de novo, right? So they're the fact finders. They do everything. And then appellate jurisdiction would mean that they would really only be reviewing for law. So this is where like it gets important, right? Like the Supreme Court should have original jurisdiction in all cases affecting ambassadors or other public ministers and consuls, and in those in which a state shall be a party. So if you want the Supreme Court to like review your case, like this is what you need to look at. Because if they don't have original or appellate jurisdiction, if they have original jurisdiction, they're far more likely to take it. And the Supreme Court is like one of those, as far as I know, is actually the only court that actually like really chooses whether or not they want to take a case or not. Like, so if you want to have a shot at even being heard at all, you need to try to find a way. This is going to sound terrible. Try to find a way where an ambassador, another public minister or consul, or a state is a party. Party meaning versus. If one of these things don't occur, then they're going to have appellate jurisdiction. And yeah, they can still look at it, but they're far less likely to look at it than if you have fulfilled one of these prerequisites. So there's strategy in that, right? Okay. It has been insisted at the bar that, as the original grant of jurisdiction to the Supreme and inferior courts is general, and the clause assigning original jurisdiction to the Supreme Court contains no negative or restrictive words, the power remains to the legislature to assign original jurisdictions to that court in other cases that those specified in the article which has been recited, provided those cases belong to the judicial power of the United States. It has been intended to leave in its discretion of the legislature to apportion the judicial power between the Supreme and inferior courts according to the will of that body. It would certainly have been useless to proceed further than to have defined the judicial power and the tribunals in which it should be vested. The subsequent part of the section is mere what? Surplusage? Google to the rescue. Let's see. Yeah, it's just surplus. Surplusage. Refers to something that is actually unnecessary or irrelevant. Much like this search was surplusage. And is entirely without meaning, if such is to be the construction. Yeah. If Congress remains at liberty to give this court appellate jurisdiction where the Constitution has declared their jurisdiction shall be original, and the original jurisdiction where the Constitution is declared to have been shall be appellate, the distribution of jurisdiction shall be in the Constitution. A form without substance is form without substance. Okay, so they're really saying like, what kind of jurisdiction do we have here? Is this us? This is all us, right? Yeah, it's a big deal. It's a big deal that they're looking at this. Okay. Affirmative words are often in their operation negative of other objects than those affirmed, and in this case, negative or exclusive sense must be given to them, or they have no operation at all. It cannot be presumed that any clause in the Constitution is intended to be without effect, and therefore such construction is inadmissible unless the words require it. Okay. If the selectitude care or concern of someone or something, cool, all right, of the convention respecting our peace with the foreign powers induced a provision that the Supreme Court should take original jurisdiction in cases which might be supposed to affect them. Yet the clause would have proceeded no further than to provide for such cases if no further restriction on the powers of Congress had been intended. Okay. That they should have appellate jurisdiction in other cases, which, with such exceptions as Congress might make, is no restriction unless the words be deemed exclusive of original jurisdiction. When an instrument organizing fundamentally as a judicial system divides it into one supreme and so many other inferior courts as the legislature may ordain or establish, then enumerates its powers and proceeds so far to distribute them as to define the jurisdiction of the Supreme Court by declaring that the cases in which it shall take original jurisdiction, and that in courts it shall take appellate jurisdiction, and in others it shall take appellate jurisdiction, the plain import of the words seem that in one class of cases, its jurisdiction is original and not appellate. In the other, it is appellate and not original. If any other construction would render the clause inoperative, then the additional reason for rejecting such other construction and for adhering to the obvious meaning. To enable this court to issue a mandamus, it must be shown that an exercise of appellate jurisdiction or to be necessary to enable them to exercise appellate jurisdiction. To enable this court is then to enable the court, To enable this court then to issue a mandamus, it must be shown to be an exercise of appellate jurisdiction or to be necessary to enable them to exercise appellate jurisdiction. It has been stated at the bar that the appellate jurisdiction may be exercised in a variety of forms, and that if it be the will of the legislature that a mandamus should be used for that purpose, then it must be obeyed. This is true. Yet the jurisdiction must be appellate, not original. Man, they're really going into this jurisdiction, right? But this is what we were talking about earlier. Like they were really trying to parse out like where the limits were and where they weren't, and limiting the amount of power that they exercise. They were really showing that like I don't want to say that the rule was like absolute, but like they really wanted to show that, hey, if we make a decision, if we render an opinion on a case, we want you to take it seriously, because we don't do it all the time. We only do it when we think it's important and when it's appropriate, right? So that was them like drawing out their power, which is a big deal, you know. Like this is non-trivial. Okay. It is the essential criterion of appellate jurisdiction that it revises and corrects the proceedings in a clause already instituted and does not create that case. Although, therefore, a mandamus may be directed to courts, yet to issue such a writ to an officer for the delivery of a paper is, in effect, the same as to sustain an original action for that paper, and therefore seems not to belong to appellate but to original jurisdiction. Neither is necessary in such a case, and this to enable the court to exercise its appellate jurisdiction. The authority, therefore, given to the Supreme Court by an act establishing the judicial courts of the United States is to issue writs of mandamus to public officers appears not to be warranted by the Constitution, and it becomes necessary to inquire whether a jurisdiction so conferred can be exercised. The question whether an act repugnant to the Constitution can become the law of the land is a question deeply interested to the United States, but happily not of an intricacy proportioned to its interest. It seems only necessary to recognize certain principles, supposed to have been long and well established, to decide it. That the people have an original right to establish for their future government such principles as, in their opinion, shall most conduce to their own happiness, is the basis of which the whole American fabric has been erected. Oof, okay. So, yeah, I mean, this is really interesting that they said this. The people have an original right to establish for their future government such principles as, in their opinion, shall be most conducive to their own happiness, in the basis of which the American fabric has been erected. So, I mean, this is really what, if I'm reading this correctly, they're really saying like, hey, Congress, the legislature, they're the will of the people, and that's what we're founded on. So whenever possible, like, Congress should really have the most power, right? Like, the exercise of this original right is a very great exertion, nor can it nor ought it to be frequently repeated. The principles, therefore, so established are deemed fundamental, and as the authority from which they proceed is supreme and can seldom act, they are designated to be permanent. This original and supreme will organizes the government and assigns to different departments their respective powers. So we're now talking about separation of powers again. It may either stop here or establish certain limits not to be transacted by those departments. The government of the United States is of the latter description. The government of the United States is of the latter description. The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written To what purpose are powers limited, and to what purpose is that limitation committed to writing, if these limits may at any time be passed by those intended to be restrained? To what purpose are those powers limited, and to what purpose is the limitation committed to writing, if these powers may at any time be passed by those intended to be restrained? Okay. All right. Like, what's the significance of that? Like, okay. All right. I get it. I mean, they're, and a lot of this is like almost rhetorical, like in the sense that remember that this a lot of this case is the court telling you like you should take us seriously. The Supreme Court is basically saying you should take us seriously because we take ourselves seriously. Like, these are the kinds of things that we think about, is basically what they're saying, right? The distinction between a government with limited and unlimited power is abolished if those limits do not confine the person on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. Oh yeah, okay. This is actually a really, really big deal. Like, they talked so much in this that like it was kind of stealth, right? They're basically saying like the legislature cannot easily alter the Constitution, and the Supreme Court is basically like the guardians of the Constitution. That is, by the way, like, I mean, they have original jurisdiction over claims of anything that regards like original breaches of the Constitution, right? So that's a big deal. Yeah. Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alternable, mean changeable, alterable. Good grief! I will, like I said, I will learn to read one day. Keep up with me, change. Yeah. It is alterable when the legislature shall please to alter it. If the former part of the alternative be true, then the legislative act contrary to the Constitution is not law. If the latter part is true, then written constitutions are absurd attempts on the part of the people to limit a power that is. If the latter part is true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable. Like the little tongue twisters, man. Okay. Certainly, all those who have framed written constitutions contemplate them as forming the fundamental and paramount law of the nation, and consequently, the theory of every such government must be that the act of the legislator repugnant to the Constitution is void. So they're saying, well, like, we stand with the people. Yeah. This theory is essentially attached to a written constitution and is consequently to be considered by this court as one of the fundamental principles of our society. It is not, therefore, to be lost sight of its further consideration of this subject. If the act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or, in other words, though it not be law, does it constitute a rule as operative as if it was law? This would be to overthrow in fact what was established in theory, and would seem at first view an absurdity too gross to be insisted on. It shall, however, receive more attentive consideration. It is emphatically the province and duty of judicial department to say what the law is. Those who apply the rule in particular cases must, of necessity, expound and interpret that law. And if two laws conflict with each other, the courts must decide on the operation of each. So if a law be in opposition with the Constitution, oh, okay, yeah, okay. If both the law and the Constitution apply to that particular case, so that the court must decide that the law conformity to the law. So if the court must decide that the case conformity to the law, disregarding the Constitution, or conformity to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty. Okay, so now they're talking about like voiding laws, right? And they're saying like, hey, if a law conflicts with the Constitution, then Constitution wins, right? It's a power structure of how laws are written, essentially. If then the courts are to regard the Constitution, and the Constitution is superior to any act of legislature, the Constitution, and not such ordinary act, must govern the case which they both apply. Those then who controvert the principle that the Constitution is to be considered in court as a paramount law are reduced to the necessity of maintaining that the courts must close their eyes on the Constitution and only see the law. This doctrine would subvert the very foundation of all written constitutions. It would declare that an act which, according to the principles and theory of our government, is entirely void, is yet in practice completely obligatory. And it would declare that if the legislature shall do what is expressly forbidden, such act, notwithstanding the express prohibition, is in reality effectual. It would be giving to the legislature a practical and real omnipotence, with the same breath which professes to restrict their powers with narrow limits. It is prescribing limits and declaring that those limits may be passed at pleasure. That it thus reduces to nothing that we have deemed the greatest improvement of political institutions, a written constitution would itself be sufficient. In America, where written constitutions have been viewed with so much reverence for rejecting the construction, but the particular expressions of the Constitution of the United States further furnish additional arguments in favor of its rejection. The judicial power of the United States is extended to all cases arising under the Constitution. Could it be the intention of those who gave it this power to say that in using it, the Constitution should not be looked into? That a case arising under the Constitution should be decided without examining the instrument under which it arises? This is too extravagant to be maintained. In some cases, then, the Constitution must be looked into by the judges. And if they can open it at all, what part of it are they forbidden to read or to obey? There are many other parts of the Constitution which serve to illustrate this subject. It is declared that no tax or duty shall be laid on articles exported from any state. Suppose a duty on exportation of cotton, of tobacco, or of flour, and a suit instituted to recover it. Ought judgment to be rendered on such a case? Ought the judges to close their eyes on the Constitution and only see the law? Okay, so they're saying like if a law and the Constitution were to conflict, like do they only look at the law? Okay. Do we ignore the Constitution? That's really the question, right? Like the Constitution declares that no bill of attainder or ex post facto law shall be passed. If, however, such a bill should be passed and a person should be prosecuted under it, Must the court condemn to death those victims whom the Constitution endeavors to preserve? No person, says the Constitution, shall be convicted of treason unless on testimony of two witnesses of the same overt act or on confession in open court. Here, the language of the Constitution is addressed especially to the courts. It prescribes directly for them a rule of evidence not to be departed from. If the legislature should change that rule and declare one witness or a confession out of court sufficient for the conviction, must the constitutional principle yield to the legislative act? From these and many other sections which might be made, it is apparent that the framers of the Constitution contemplated that the instrument as a rule for the government of contemplated that instrument as a rule for the government of courts as well of the legislature. Okay, all right, cool. Seems pretty straightforward. They're saying like, hey, we should include it. We should look at this. We should consider this. Why otherwise does it direct the judges to take an oath to support it? This oath certainly applies. This oath certainly applies in a special manner. Why otherwise does it direct the judges to take an oath to support it? This oath certainly applies in a special manner to those conduct in their official manner. How immoral to impose it on them if they were to be used as instruments, and the knowing instruments for violating for what they swear to support. That oath of office, too, imposed by the legislature, is completely demonstrative of legislative opinion on the subject. It is in these words: do I solemnly swear that I will administer justice without respect to persons, and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge all duties incumbent to me as according to the best of my abilities and understanding, and agreeably to the Constitution and laws of the United States. Why does a judge swear to discharge his duties agreeably to the Constitution of the United States if that Constitution conforms no rule for his government, if it is closed upon him and cannot be inspected by him? If such be real states of things, this is worse than solemn mockery. To prescribe or to take this oath becomes equally a crime. It is also not entirely unworthy of observation that in declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only shall be made in pursuance of the Constitution have that rank. Thus, the particular phraseology of, that seems like a science, phraseology, okay, of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, and the law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. The rule must be discharged. Oof. Okay. That was a really, really long opinion. Yeah, that was a super long opinion. Like usually, and I, of course I said, hey, you should always start with the opinion first. This is like the one case that, well, you should probably start with the facts. So we're going to look at the facts now, and maybe all this stuff will make sense, right? By the way, here's something to pay attention to, right? Like, Marbury is suing Madison, and he's trying to get Supreme Court support. So something to look at politically for the time was, how would it look at the Supreme Court backed a judge that is being accused of behaving inappropriately, right? So let's look at the facts, and that'll tell us like a little more, right? Okay. So they did a a shortcut, right? Like this is what you would see in summaries. Congress does not have the power to pass laws that override the Constitution, such as by expanding the scope of the Supreme Court's original jurisdiction. And that's really what this whole case was about, right? Like, um, and as you saw in this super long opinion, the court was like, "This isn't our place, and if we accept this power, then we're going to dilute the purpose of the separation of powers, and inevitably we would end up losing power because of it." It's a real funny like way of doing things, but yeah. So let's see. Facts. Thomas Jefferson defeated John Adams in the presidential election of 1800, which was decided on February 17th of 1801. Before Jefferson took office in March the 4th, Adams and Congress passed the Judiciary Act of 1801, which created new district courts and expanded the number of circuit courts, added more judges to each circuit, gave the president more control over appointing the federal judges, and reduced the number of Supreme Court justices from 6 to 5. This law essentially was an attempt by Adams and his political party to frustrate the incoming opposition, since he used his new power to appoint 16 new circuit judges and 42 new justices of the peace, a group known as midnight judges. The incoming appointees were approved by the Adams Senate, but their appointments were not valid until each of their commissions was delivered by John Marshall in his capacity acting Secretary of State. Justices of the peace were entitled to serve a term of 5 years. One of the new appointees was William Marbury, a long-standing supporter of Adams, who received the position of Justice of Peace in the District of Columbia. As was the case with a handful of new other appointees, Marshall failed to deliver Marbury's commission before Adams left office and was succeeded by Jefferson. Oh, okay. So that's what they're talking about, the writ, right? Like, the writ was like about, not the writ of mandamus was about like getting the actual document, basically. With the change in administration, Marshall also left his position as Secretary of State and was succeeded by James Madison. However, Jefferson ordered acting Secretary of the State Levi Lincoln to cease delivering the commissions, thus preventing the new appointees from taking their positions. He assumed that they could be considered void since they were not delivered on time. The machinations did not end there, moreover. The Jefferson Congress proceeded to replace the Judiciary Act of 1801 with a new Judiciary Act of 1802 that essentially restored the initial Judiciary Act of 1789. So they're doing all this like legislative judo, right? Okay. It also sought to delay the Supreme Court in hearing the inevitable challenge to the constitutionality of Jefferson's maneuver by canceling his term in June 1802. Marbury then filed a writ of mandamus. The writ of mandamus to the Supreme Court asking to order the executive branch to deliver his commission. See? That's what we're talking about here. Okay. Marshall and This was a rare case that arrived in Supreme Court and as the court of original jurisdiction rather than its appeal from the lower court. Marshall and the other justices needed to determine not only whether Marbury had the right to his commission, but whether he had a remedy that could be enforced through the courts. This is, by the way, not the way most cases are written. Most of the cases you'll see, like in law school and stuff like that, they're not written like this. It's not like, you read, it's not super straight cut like this. But then this is one of the first cases, so, maybe that's why. Like all this, like the way that they wrote this background, it's not usually like this. Okay. Had a right to his commission, but whether he had a remedy that could be enforced through the courts. Marshall found that a remedy could be implied because no right could exist without a remedy. Also, delivering the commission was the purely ministerial function of the executive branch. By ordering it to comply with its ministerial duties, the court would not violate the separation of powers by encroaching on another branch's discretion. Marshall also ruled that a writ of mandamus was a proper way of seeking a remedy, but grappled with the question of whether the Supreme Court could issue it. He identified a conflict between the Judiciary Act of 1789 and the Constitution, each of which provided different parameters for the court's original jurisdiction. Marshall rejected Marbury's argument that the Constitution merely served as a foundation on which Congress could build with later laws, finding that the Constitution trumped any laws and the Congress did not have the power to modify the Constitution through regular legislation. In explaining why the Constitution was supreme to all laws, he noted that the Supremacy Clause places the Constitution before the laws, and the judges must take an oath to uphold the constitutionality as a result. Marshall found that the section of the Judiciary Act of 1789 was purported to give the Supreme Court original jurisdiction over these matters was invalid because it violated the Constitution. Okay, yeah. So again, this was all about like interpreting the Constitution and whether or not the Supreme Court should even have seen this case at all. That was really the thing, right? The Supreme Court consisted of only 6 justices at the time, so Marshall's 4-justice opinion was unanimous because 2 of the judges recused themselves. Okay, so these 2 justices didn't even participate. They had a conflict of interest, basically. Case commentary. I'm gonna skip this because I've already been doing that. Okay, yeah. Okay, well, so that's it. Like I said, this case is like unusual in the way that it's written for what you would see in like a case book. This is not how you would normally see it. So, yeah, and okay, so let me start here. If you're watching this and this is like the first legal case you've ever seen, you're like, oh no. Especially if you're thinking, maybe I should like watch one of these videos and like get a sense for whether law school is right for me and like whether I'll like make it, if I can survive there and like, whether this is like the thing for me. This is a horrible example for how law school is generally and how the legal industry is generally. Like, is there some cases that are super dry like this? Yes, there are some. A lot of them are not this bad, frankly. Some of them are, this is going to sound terrible, dare I say somewhat entertaining. Because, if you really pay attention to it, like you're seeing it's almost like a movie playing in your head, right? Like this person said this and this person did that, To an extent, maybe that's why we make movies about legal cases. Like there's some really famous cases that there's been movies made out of, like real cases. And I'm not talking about, what was that? I forgot the name of the movie with Tom Cruise. Like, I'm not talking about, like, that's not based on a real case, But like, for example, Bridge of Spies, right? Like, that movie's amazing, right? With Tom Hanks. And that was based on a real case. Like, Donovan existed. I don't know how much of the movie was dramatized, but yeah, Donovan was exceptional in his legal and negotiation skills. Yeah. So I don't want you to get too freaked out if you're watching this and thinking, you know what, I know if law school's like this, no. I don't want you to do that, okay? Because this is a terrible example for what like the rest of it would be like, okay? I would say this is like the peak of like the worst for the most part. There are a few. Like I said, there are a few. Like in I think in every course there's like maybe 1, maybe 2 that are like this, where it's just like you leave afterwards and you're like, what did I just read? It's gonna take you a little bit. I've read this, 5 something years ago, and I'm reading it again, and it's almost as confusing now as it was back then. I understand it now because I've had some time to process it, but like reading it over, yeah, it's written differently. It's not written badly. It's written very well for its time, but people spoke differently. People thought differently. You know, if this was rewritten today, for example, it would be easier for us to interpret because it would be in a more modern language, right? So, anyway, if you have any suggestions for what you would like to see different, besides the video being shorter, which I totally understand. I think we're at like close to 2.5, 3 hours right now. It's super long. Again, this is a super long case, which is why it's so long. And normally they're not normally this long. But if you have other suggestions, let me know. I'm all ears. All right. See you next time. Bye.